Thank you, Honorable Abante. That finally concludes our sponsorship speeches. Honorable Suntay, if this concerns the sponsorship speech, because soon we will be proceeding to hear on the sufficiency in form, if that concerns form. Kindly use the microphone of the Honorable Patiernos.
We're back.
That's only the microphone.
Wala pang ano.
Page, kindly fix the microphone near to Honorable Suntay.
Hello po, ayan.
Okay.
Check this. Thank you very much, Madam Chair. Well, Madam Chair, after hearing all the endorsers of the impeachment complaint, sangayon naman ako sa kanila dahil ang mga sinabi nga natin mga endorsers, there has been allegations now of misuse of hundreds of millions of public funds. Merong mga sworn affidavits, merong mga allegations na binitawan, merong usapin regarding betrayal of public trust, graft and corruption. Kagaya nga ng sinabi ni Congresswoman Renico, hindi dapat tayo matakot ungkatin ang katotohanan. At kagaya ng sinabi ng aking kaibigan, si Pastor Benny Abante, public office is a public trust. We should proceed with fairness and without fear. Bottom line, we have to be impartial. That's why I would like to raise this. In the light of serious allegations contained in a joint affidavit issued last February 23, that has been reportedly transmitted to the Office of the Ombudsman, there have been allegations that some members of Congress nakatanggap ng envelope, nakatanggap ng maleta. Ito'y naibigay, kung hindi sa opisina, sa townhouse. No, let me finish.
There's
You
a
will have
point
your
of
turn
order,
because
the
this is
Honorable
hearing.
Suntay.
This is not an allusion
Order.
to prejudge the veracity of the allegations.
Honorable Suntay, there is a point of order.
This is also a point
That
of order.
includes the highest
Mayor.
hierarchy
Of,
among all the
what is
motions.
the relevancy of this speech?
No.
Of sufficiency in form?
Madam Chair, this is very relevant because we are
Please, Honorable Suntay, please wait until he finishes with his point of order. The Honorable Terry Ridon is recognized. Kindly use a microphone which is okay.
Madam Chair, the speech of our distinguished colleague is absolutely relevant to the question of sufficiency of form and substance in the matter. And more importantly, my understanding of what he's stating today is that he's probably accusing members of Congress, members of the House Committee on Justice, as receiving payments for the implementation of our mandate in the impeachment proceeding. So, which is which, Madam Chair? So I think his speech is out of order and this should be decided promptly by the committee.
Okay, we heard the basis of the point of order of the Honorable Terry Ridon. Now we shall hear the answer of the Honorable Suntay.
Yes, Madam Chair. Ang problema sa
Kindly
kaibigan ko,
justify the relevance of your
He is
statement to the
jumping the
current
gun.
impeachment proceedings.
he is jumping the gun. This is actually relevant not only in the determination of form and substance. This is relevant in the impartiality, in determining the impartiality of this hearing, which is very important. Madam Chair, this is not an accusation. Kaya nga, kung hinintay lang ako patapusin, ewan ko, bakit naman yung aking kaibigan, naggagalaiti ka agad at concern na concern. You know, if we have nothing to hear, then we have Well, we just listen. If we are not being alluded, why are we so guilty? So let me finish. The issue here is not to prejudge the veracity of the allegation. However, given the gravity of the claims and the potential impact on the credibility of the committee's proceeding, ang gusto ko maging malinaw lang po, hindi ko hinuhusgahan yung aking mga kasamahan o ipagpalagay na totoo ang mga aligasyon. Hindi rin po ito personal na laban sa sino man sa inyo. Sa katunayan, ang layunin ko ay kabaligtaran upang protektahan ng bawat isa sa inyo. Mabigyan kasi may listahan na nilabas eh. Ang gusto ko po sa ganitong pagkakataon, Madam Chair, naniniwala ako na mas mabuti na tayo mismo ang magharap at maglinaw ng issue. Kaya maging bulok kaysa maging bulong-bulungan pa ito. Bigyan natin ng pagkakataon bawat membro ng committee. Pagkakataon mismo na mag-assess ng kanilang sitwasyon. Or if they can be an impartial member of this committee. Yun lang. Kung sa tingin nila, they can be an impartial, then let's proceed. However, if they think that baka pagdudahan sila at pagdudahan yung lalabas dito na resulta, then let's allow them if they want to recuse.
Honorable Suntay, with all due respect, unless all your manifestations have complete relevance to the current impeachment proceedings, you're enjoined by the chair to proceeding to your manifestation.
That's why, Madam Chair.
So ordered.
Madam Chair, my point is just to...
Honorable Sunta, you're enjoined already by the chair to cease from making manifestations which are totally irrelevant to our current proceedings.
Okay, thank you, Madam Chair. But as I mentioned, this goes to the impartiality of the committee.
You are
Thank you
assured
very
of the impartiality of the Justice Committee. Now we shall proceed to the determination of sufficiency in form. Thank you, Honorable Suntay. We will be suspending for 2 minutes to fix all the microphones. Ano uling sa? The meeting is resumed. We will now proceed to the determination of sufficiency in form.
Madam
If the other
Chair.
members,
Madam
the
Chair.
Honorable Diaz Guerin.
Madam Chair, prior to proceeding with the indulgence of the members of this committee, since the allegations were baseless and not contained in an affidavit, and this is the subject of an impeachment complaint totally unrelated to what was mentioned, may I move that the words and the allegations as contained for congressmen getting money in the office and being delivered in the townhouses be stricken off the records. So moved, Madam Chair.
There is a motion to strike off from the record the manifestation of the Honorable Suntay with respect to the money taken or received in relation to the
Basically, Madam Chair, the statements, the allegation mentioned by Congressman, or my good friend, my very good friend, Congressman Suntay,
you are good friend to each other.
Very, Madam Chair.
Very much, Madam Chair. So,
There is a motion to strike off from the record the manifestation of the Honorable Suntay about the money taken or received allegedly by the members of the House. Is there a
Madam Chair.
second? The same has been seconded. Is
Madam
there
Chair.
any objection?
Madam Chair.
Are you-
Madam Chair, I have no objection considering it has been published.
The Honorable Marcoleta, are you objecting?
No, ma'am. In fact, I'm appealing to
Let us resolve first the motion.
reinstate the.
So you are objecting.
No, I'm appealing to reinstate the remarks earlier made by.
The motion is still pending. It's not yet resolved. If there are no objection, then the chair approves the motions to strike off from the record the manifestation of about the money allegedly received by the House members from the manifestation of the Honorable Suntay. So ruled. Honorable Marcoleta.
Madam Chair, I'd like to appeal. I think the remarks earlier made by Honorable.
Is that a motion for reconsideration?
It's more of a manifestation.
Okay, please manifest.
Opo. The earlier remarks made by Honorable Suntay is an appeal for objectivity, impartiality, insofar as the proceedings of the Justice Committee is concerned. Ang binanggit po niya, if we will, no offense to the most of the members of the Justice Committee, there are 25 House members named in the affidavit of the 18 ex-Marines, 25 names, which comprise around 1/3 of the membership of the Justice Committee here, all present.
The Honorable Marcoleta is likewise reminded to confine the manifestation to the relevancy of the current impeachment
I
proceeding.
think it's very germane, ma'am, because we will, it boils down to the objectivity and impartiality of the members.
Honorable Marcoleta, we have not reached even the determination of sufficiency in form, and the chair has stated already that the Justice Committee is assured of the impartiality of the chair, including all the members. I think that is premature for us to discuss on the partiality when we haven't heard any of these impeachment complaints. So unless the manifestation has relevance to the current impeachment proceeding, the Honorable Marcoleta is requested to cease from making manifestation outside the subject matter of this impeachment proceeding.
Madam Chair, with due respect to the 25 members who were mentioned in the affidavit,
Honorable Marcoleta, you're reminded by the chair already to confine to the subject matter of this impeachment proceeding. If you continue to make a manifestation outside the subject matter, we will be ruling you out of order. With all due respect, Honorable Marcoleta.
I submit to the wisdom of the chair.
Thank you. We shall now proceed to the determination of sufficiency in form. For the guidance of all the members, in determining sufficiency in form, we will be dealing with the following questions. Number 1, whether the impeachment complaint was signed. Number 2, whether the impeachment complaint was properly verified. Number 3, whether there was a proper endorsement by a legitimate incumbent member of the House in cases filed by citizens. Number 4, whether it was included in the order of business within 10 session days. and referred to the proper committee within 3 session days. Number 5, whether the impeachment complaint is compliant with procedural formatting and jurisdictional requirements. And last, whether the impeachment complaint complies with the 1-year bar rule. We will be holding our deliberation one impeachment complaint after the other, beginning with Castro et al. Impeachment complaint, followed by Father Sabalia et al. Impeachment complaint, and finally by Cabrera impeachment complaint. After all the deliberations are concluded, the justice members will be proceeding to vote again one after the other impeachment complaints.
Madam
To
Chair,
begin with,
Madam Chair,
I was about to call you Honorable Tino. What is the pleasure of the Honorable Tino?
no, a parliamentary inquiry based on the pronouncement of the chair as to the scope of determination of sufficiency in form. In our rules, malinaw po, a verified complaint for impeachment by a member of the House or by any citizen upon a resolution of endorsement by any member hereof shall be filed with the office of the Secretary General and immediately referred to the Speaker. An impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. So those are the parameters for determining sufficiency in form. My concern, Madam Chair, is that the Chair mentioned additional matters such as, for example, whether or not the filing of the complaint complies with the 1-year bar. Wala naman po sa explicit rules on impeachment yon. And in fact, let me note that the 1-year bar applies to an impeachment proceeding, not the filing of a complaint, but the initiation of an impeachment proceeding. No, kaya po nagtataka lang po tayo bakit nadagdagan po ng mga kailangang i-determine ng committee ito at this point when the rules are very clear. We only have to deliberate whether or not the complaints are verified and whether endorsed by a member of the House, Madam Chair.
Before the Honorable Flores respond to the manifestation of the Honorable Tino, we would like to recognize the Honorable Micah Gonzalez, Deputy Majority Leader, the Honorable Ana York P. Bondoc from the 4th District of Pampanga, and the Honorable Ramon Rodrigo L. Gutierrez from the One Rider Party List. The Honorable Flores is recognized.
Thank you, Madam Chair. Madam Chair, tama naman po yung sinabi ni Congressman Tino na hindi siya specifically mentioned yung timeliness. But I think it should be part of the consideration in determining form, Madam Chair, kung timely nga ba yung pag-file ng isang impeachment complaint. Because it would be useless for us to consider any impeachment complaint that was filed within the 1-year bar period, Madam Chair. And I think it is important that we determine it together with the other formal requirements of the impeachment complaint na dapat nga may, kung ako nga lang ang masunod, dapat part of the verification should include a statement that this complaint was filed na outside of the 1-year bar rule if there is any. Because it would be, again, useless for us to determine the validity of the form if we know for a fact that it was filed well within the 1-year bar rule, Madam Chair.
Madam Chair,
All right? The Honorable Tino.
Madam Chair, if I may, the Constitution itself says, with respect to this 1-year bar, that no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. So it speaks of initiation of impeachment proceedings within 1 year being barred. No, proceedings. Hindi po sinabing filing of complaint. And it is very clear in our own rules and in jurisprudence that an impeachment proceeding is initiated not by the filing of a complaint, but by referral of plenary of the complaints to the Committee on Justice. Hindi po ba malinaw yun, Madam Chair? So, kaya po, tingin ko, bakit po ginagawang issue ang hindi naman issue? The Constitution, yan po ang pinakamataas, no? Nagsasabi, ang barred for 1 year is the initiation of an impeachment proceeding, not the filing of a complaint. The filing of a complaint does not initiate a proceeding, Madam Chair. So, Madam Chair, please enlighten this representative kasi nga, lumalagpas po tayo sa konstitusyon, no? Sa nais niyong pag-include ng timeliness of filing. Wala naman pong ganung rules, Madam Chair.
The Honorable Flores is recognized.
Thank you, Madam Chair. Madam Chair, the Supreme Court in its decision noong July 25 to 2025 clearly said that no new impeachment complaints, if any, may only be commenced no earlier than February 6 of 2026. That was clearly stated by the decision of the Supreme Court in July 2025. And while it may not have been stated, as correctly pointed out again by Congressman Tino, na ito lang yung sinabi ng Constitution natin, but in interpreting that provision of the Constitution, the Supreme Court came out with this decision that no new complaints may be commenced no earlier than February 6 of 2026. And it is silent on this point on its resolution of the motion for reconsideration noong January 2026 po. Madam Chair.
The Honorable Ridon, Madam Chair. And then the Honorable Chua, and then the Honorable Patiernos, and then the Honorable Suntay.
Well,
Honorable Ridon first.
And then Madam Chair.
Well, before proceeding further, Madam Chair, I think what the endorsers wanted to do is to reframe the matter, no? That we should not discuss it as part of sufficiency and form. But, and if this is not the situation that they want to find themselves in, I think we have to discuss it as a threshold question. And whether or not their filing is actually barred based on the Supreme Court decision and all other relevant constitutional provisions and rules of impeachment proceedings, no? So is that the pleasure of the endorsers, Madam Chair?
May we request the Honorable Tino to confirm whether your concern is only to consider the compliance to one-year bar rule as a preliminary matter instead of including that in the determination of sufficiency in form?
My position, Madam Chair, is that the question of timeliness is not relevant at all to these proceedings because the initiation of the impeachment proceeding is well after the so-called one-year bar.
Nonetheless,
Based not on the original decision of Duterte versus House of Representatives, but on the ruling on the motion for reconsideration, no? So, and Madam Chair, perhaps I will.
just for clarity, Honorable Tino, would you like to discuss the one-year prohibition period prior to our determination of sufficiency in form? Is that your pleasure?
Sabi ko nga, Madam Chair, na-anticipate ko na merong tutulad sa yumaong si Congressman Edsel Lagman, and they will raise a prejudicial question before the actual deliberation on sufficiency in form. No, I do not. I am not.
So what is the pleasure of the
Moving forward.
Honorable Tino?
Okay, I am merely actually okay. If I may,
Because
I
there
would
is
like to raise a point of order. Therefore, that deliberations on so-called timeliness of filing is not within the scope of this stage of the impeachment proceedings. No, because we are, as the chair mentioned herself, in the period of determination of sufficiency in form, and as our rules very clearly state, no, that consists of determining whether or not there is a verified complaint and whether or not this is duly endorsed by a member of the
What
House.
actually is the point of order of the Honorable Tino? Is it your intention that to actually set aside the discussion of one-year bar rule in
Yes,
relation
Madam
to
Chair.
your complaint?
Yes, Madam Chair.
Madam Chair.
Madam Chair,
Madam Chair.
The Honorable Chua first and then the Honorable Flores.
yeah, if I remember it correctly, the Honorable Tino manifested a while ago that he wanted to be clarified with respect to the word initiated. Tama po ba? Yes. Now, let me just clarify it. Let me walk you through the case of Supreme Francisco versus the House of Representatives. Your Honor, Madam Chair, in that case, the Honorable Court states that the impeachment proceeding are initiated upon filing of the complaint and or resolution and its referral to the committee. Therefore, there are two acts that should be followed. First, the filing of the complaint. That's why the filing of the complaint is also necessary because that will determine the one-year bar rule. That is included in the determination of the one-year bar rule. Now, as already manifested a while ago, already expounded or explained by the Honorable Vice Chair Flores, that in the first decision of the Supreme Court, it stated expressly that no impeachment complaint should be filed earlier than February 6. And in the second decision, there is no such express statement from the Supreme Court. There is this so-called statutory construction between two conflicting laws, one express and the other one implied. The express should follow. Now, having said that, Your Honor, I believe that it is mandatory and it is necessary that we should first determine if this is filed within the one-year bar rule. Why? Otherwise, this will all be inutile, useless, if eventually this will again be used in the court to question the legality and constitutionality of this first impeachment complaint. Thank you, Madam
Honorable
Chair.
Chua, is it
Madam
your
Chair.
intention to
Object.
hear the discussion on one-year compliance prior to the determination of sufficiency in form?
Yes, Madam
Would
Chair.
you like to raise a motion to that effect?
Yes, I would like to move that we discuss the one-year bar rule prior to the determination of form and substance. Madam
There is a
Chair.
motion to discuss compliance to one-year prohibition period before we proceed to the determination of sufficiency and substance. Do I hear a second? Is there any objection? Hearing none, the motion is approved. We shall now open the discussion as to the compliance to one-year prohibition, but in doing so, we will do it one complaint after the other. To start with, we are calling the endorsers of the first impeachment complaint to manifest their position with regards to their compliance to the one-year prohibition period. A quick manifestation only because I understand that you have made ample discussions already on that in your sponsorship speech. The Honorable Ko is recognized.
Madam Chair, although Madam Chair, I'd like to clarify that in our sponsorship speeches, we have not yet taken into consideration the one-year bar rule. So I'd like to manifest and be able to provide some opportunity to explain po.
Yes, please proceed.
Thank you, Madam Chair. Madam Chair, it is the position of this representation that the first impeachment complaint, Castro et al., and as endorsed by the representatives herein, respect the law that has been provided already. It is in full compliance with the Constitution and is not within and is not violative of the period of the 1-year bar. I'd like to walk through the different rules and proceedings that are applicable. Firstly, the Constitution provides the overarching framework. Article 11, Section 3, subsection 2 provides that a verified impeachment, complaint for impeachment, may be filed by a citizen upon a resolution or endorsement, and it shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. Gusto ko lang din i-point out that Article 6, Section 16, subsection 3, generally provides then the framework that each house may determine the rules of its proceedings, including the House of Representatives. That's why po may House rules tayo, may specific rules tayo on impeachment proceedings na sinusunod po natin ngayon. To supplement, Francisco versus House of Representatives provide. It says that the initiation takes place by the act of filing and referral or endorsement of the impeachment complaint to the House Committee on Justice, etc. So, also in response to the argument by the Honorable Representative Joel Chua earlier, which says that there are 2 acts, filing and referral, that's true. Pero kung titignan din naman natin sa praktikalidad, titignan natin yung date, ano ba yung material date dito, it is the referral. Dito po, here and in other instances, tinitignan kung kailan po nagkaroon ng pagsisimula ng 1-year bar period. And so according to Francisco, sa pag-alam kung kailan magsisimula ang 1-year bar, the pertinent date is referral date. Dinigdagan naman po ito ng Duterte versus House of Representatives just this January 2026. Nire-affirm niya ang Francisco versus House of Representatives and ruled further. Meron pong 2 other instances kung saan may for the purposes of initiation of the 1-year bar, kinonsider. Yung una, yung discuss na sa Francisco, yung referral to the Committee on Justice. And I am quoting here, the 4th point of the Duterte versus House of Representatives of 2026. This is in pages 4 and 40. Number 1, referral to the Committee on Justice. Number 2, it is properly verified and endorsed by a member, and it is not put in the order of business or referred to the proper committee within the constitutional periods. Number 3, properly verified and endorsed siya or properly referred to the committee but has not been acted upon by the House upon its adjournment sine die. So, kung may filing na pero hindi nasunod ang constitutional dates na dapat nasa order of business na within 10 session days o page 30 provides that the respondent house had until January 14, 2025 to include the complaints in the order of business and until January 21 to refer to the proper committee. I'm talking about po yung naging 19th Congress impeachment proceedings. Kung nalagay po ito sa order of business noong January 13 or 14, yun po yung limit, hindi po sana matitrigger yung B kasi magiging proper yung referral. Pero hindi ito nangyari. Nangyari lang po ito noong February 5, 2025. Kaya starting January 15, 2025, batay sa desisyon ng Korte Suprema sa Duterte versus House of Representatives, naging non-compliant with the constitutional periods ang impeachment proceedings, thus triggering the 1-year bar rule. Dahil po dito, Madam Chair, na-observe natin tong 1-year bar period. And then, February 2, 2026, final ang Castro et al. Complaint, 1 year and 18 days after January 14, 2025. Ang 10th session day matapos ang filing ng impeachment, first impeachment noong December 2, 2024. So therefore, hindi po ito barred. Ni-refer naman ang mga impeachment complaints na ito on February 23, 1 year and 27 days after January 14, well beyond at lagpas-lagpas na sa period of the 1-year bar. It also bears mentioning na pasok ito sa constitutional periods. The first filing was on February 2, and 8 session days after, on February 23, pinasok ito sa order of business at nirefer sa House Committee on Justice. And also, responding to the earlier argument that they may specific citing of a date, in the Duterte versus House of Representatives 2025 decision, and then na silent po ito no sa 2026 decision. If we look at no kung ano yung nakalagay po doon sa pag-rationalize ng court, no, ano na yung bagong impeachment, ano na yung bagong rules no sa bar na i-observe or sa period ng 1-year bar, no, ito po ay overturned. So I'd like to emphasize no, we are in the ambit of essentially letter A of Duterte versus House of Representatives now. No, and yung filing po ng 19th Congress falls under letter B, no? And ang pertinent date po doon is yung start na hindi po nasunod yung constitutional period of the order of business sa pagpasok ng order of business, which is on January 14. And therefore, since na-file po ito on February 2 and na-refer to the Committee on Justice, napasok dun sa order of business, itong impeachment proceedings on February 23. Now, this is all beyond the 1-year bar period. And I'd like to make a last manifestation, Madam Chair. No? Baka isipin ng napakarami ng mga teknikalidad lang tong mga to. For us, no, these aren't mere technicalities. This discussion is political in the most fundamental sense of the word. It goes into the heart not only of the impeachment process, but the balance of powers this republic is built upon. It will determine how the legislative branch will stand on its authority as a separate branch of power now and in the future whenever this can come into question. No, kapag tayo, nakita naman natin at tumitindig tayo na this is all initiated and the proceedings are conducted well beyond the 1-year bar period, no, hindi po dapat tayo matakot sa any form no, of suit na maaaring i-file against the House of Representatives dahil tayo ay nag-comply naman sa mga rules and regulations, hindi lang po na sinet dito sa House, but also under the Constitution. That's all, Madam Chair. Thank you very much.
Madam Chair.
Thank you. I understand that the position of the endorser, Honorable Ko, is very comprehensive. So, may I manifest that the same is adopted already as the position of the two other endorsers. No?
Madam Chair.
At this juncture, we would
Madam
like
Chair.
to recognize Honorable Chua and then Honorable Rodriguez and
Madam
then
Chair.
Honorable Sunta.
Thank you, Madam Chair. Thank you, Madam Chair. Just a quick manifestation, Madam Chair. Hindi naman po tayo natatakot. We would just like to exercise circumspection. So lamang po natin mag-ingat. Lest, ganun na naman po mangyayari. After what happened in the last impeachment complaint, baka mamaya, wala na naman po mangyari dito by sheer technicality. Now, having said that, Madam Chair, when we interpret the decision of the Supreme Court in Francisco, we should interpret it as a whole by including the filing. Hindi naman po sinabi dito na or eh. Ang sinasabi dito, filing and referral. So ibig sabihin po nyon, one, hindi po natin po pwedeng i-consider yung isa nang wala po yung isa. So dapat po yan, pag kinu-consider po ninyo, para po yung kambal. Lagi po yung magkasama. Yun lamang po, Madam Chair. Thank you po.
Thank you.
Madam
Next
Chair.
is the Honorable Rodriguez.
Thank you, Madam Chair.
The Honorable Erice will be called after the Honorable Flores. Honorable Flores is number 6. But before we proceed, just for the guidance of everyone, the first impeachment complaint was filed on February 2. That is prior to the February 6 allowable date of filing as expressly pronounced in the decision of the Supreme Court dated July 25, 2025. The issue, therefore, which we are deliberating upon is whether or not the first impeachment complaint is in compliance with the 1-year prohibition period. The Honorable Rodriguez, you may proceed.
Madam Chair, the four pertinent dates on the impeachment complaint in 2025. It's first, February 2, the first impeachment complaint. December 2. Next, December 4. Next, December 19.
Supreme Court decides February 6. However, Madam Chair, in that motion for reconsiderations which we have read, clearly that particular February 6 had been modified because a later decision like an MR will therefore be able to amend and repeal whatever has been stated if it's in conflict with the recent decision, and that is the motion for reconsideration. And therefore, in this case, having read the decision and stated by the Honorable Reneco that there was a problem in the 19th Congress because there was no referral and the following of the constitutional provisions and the cases and the case of Francisco versus House of Representatives. And so therefore, in that particular case, the Supreme Court in fact said that the impeachment, the dates that are in the Constitution should not be session days but calendar days. Well, in that case, Madam Chair, it is also an overreach because by December 19, we're having a break. So we are right, the leadership is right now considering that we should only count session days. We will not be calendar. Otherwise, if that was the case, then we will therefore there's no more chance to be able to refer that. But the situation is, I may not agree with January 15, but if you will compute when you resume, considering that there will be 10 days, then the period will end in the last week of January if we count on calendar, on session days. Therefore, the filing on February 2 is within the time after the 1-year bar. So it has elapsed either February 15 or January 30. February 2 is therefore a correct timing to file the decision, to file the complaint. Therefore, on the issue of threshold, Congressman Ridon is correct. It's a threshold issue because the Constitution and the jurisprudence on Francisco is written in our rules because that is the Constitution, the highest fundamental law of the land and the highest court. And so therefore, Madam Chair, clearly the February 2 filing is within the constitutional provisions. Thank you, Madam Chair.
Thank you, Honorable Rodriguez. Next in line is the Honorable Suntay.
Thank you, Madam Chair. Well, I would like to agree with the opinion of my esteemed colleagues, Congressman Chua, and our Vice Chair, Congressman Flores. Initiation and commencement are two distinct things. An impeachment complaint is commenced by the filing of the complaint. Kung wala yung complaint, there is nothing to commence. Under the ruling of Francisco, initiation is a two-step process. First, the filing, and then the referral to the Committee on Justice. The 2025 decision was very clear. No impeachment proceeding may be commenced. Commenced yung ginamit na salita, hindi initiated. So, what is commenced? As I mentioned earlier, the filing of a complaint commences the impeachment proceeding. So, very clear then that no impeachment proceeding may be commenced prior to Feb 6. Meaning to say, yung Feb 2 was clearly filed within the 1-year bar period. Now, assuming na hindi natin kinukonsider yung 26. Kasi alam mo, yung 25 ruling was very specific. Yung 26 ruling was silent on this matter. So, as we all know, ang controlling dyan is yung specific. If there was a specific date na binigay. Now, assuming na yung initiation yung pinagbabasihan natin, shouldn't the two-step process also be within outside the 1-year period? Kasi ang mangyayari, para bang manananggal yan, yung initiation, yung filing ng complaint, pasok sa 1 year, pero yung referral, labas sa 1 year. So, ano yung magiging decision? I agree with Congressman Chua, hindi naman natin dinidiscount na maaaring sufficient in form, pero dapat pag-usapan kasi baka masayang. Baka later on, itatakbo sa Supreme Court, at sasabihin ng Supreme Court, barred yan eh. Then, everything that we're doing here would be for naught. Thank you, Madam Chair.
Thank you, Honorable Suntay. Next is the Honorable Suwan.
Madam Chair, I agree with the position of Congressman Bong Suntay because the Supreme Court in its decision on July 25, 2025 was very clear. It held that no new impeachment complaint against the respondent, if any, may be commenced. The word was commenced no earlier than February 6, 2026. The Supreme Court did not speak casually. It was construing Article 11, Section 3, Subsection 5, which provides in unmistakable language, no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. So, if a complaint was filed on February 2, 2026, 4 days prior to February 6, 2026, then we must confront a fundamental question. Are we within the constitutional window? Because, Madam Chair, if we are not, then this committee risks proceeding without constitutional footing. Madam Chair, it is important to answer this question because the one-year bar was deliberately placed by the framers to prevent impeachment from becoming a weapon of constant political siege. In fact, it exists to protect the stability of governance regardless of who occupies the office. The one-year prohibition, therefore, is a constitutional shield, not a technical obstacle. Madam Chair, this is not about shielding any individual from accountability. It is about ensuring that when accountability is pursued, it is done within the exact bounds of the Constitution.
Thank you, Honorable Suwan. Next is the Honorable Ridon.
Madam Chair, I think we need to
Is
restate.
your position?
No, we have to restate what had been said by the Supreme Court in the resolution itself. In Duterte versus House of Representatives, and I will quote it. Fourth, complaints based on the first mode or Article 11, Section 3(2) is deemed to have been initiated for purposes of the one-year bar under Section 3(5) when A, it is referred to the Committee on Justice, B, it is properly verified and endorsed by a member of the House of Representatives, and it is not put in the order of business or referred to the proper committee within the constitutional periods, and C, it is properly verified and endorsed, or it has been properly referred to the proper committee but has not been acted upon its adjournment sine die. It needs to be stated, Madam Chair, that the first impeachment complaint against the Vice President was filed on 2 February 2026 and was just transmitted to the Office of the Speaker on Feb 5, 2026 without referral to the Committee on Justice yet. The referral to the committee was done on 23 Feb 2026, and as such, the first impeachment complaint against the Vice President should not technically be precluded by the one-year bar, as it was filed only prior to 6 Feb 2026 and not initiated prior thereto. And more importantly, an argument may be made that because of the Supreme Court resolution, the amendment of the definition of the term session days had basically redefined the periods for initiation, Madam Chair. But frankly, the committee will have to contend with the question on what the Supreme Court decision actually stated expressly, which was no impeachment complaints may be referred on Feb 6, 2026. Madam Chair.
Thank you. Next is the Honorable Flores.
Thank you, Madam Chair. Madam Chair, again, i-emphasize ko lang po ito, no? Na sa decision ng Supreme Court noong July of 2025, it mentioned the date 3 times. First, on the adjudicative rulings on page 6. Second, in the summary on page 94 of the decision. And third, in the dispositive portion on page 95 of the decision. So, klaro po na sinabi nila na walang pwede makommense prior to February 6 of 2026, Madam Chair. So, well, it may be implied because nga sa resolution is iba din yung computation nila sa session days. Pero obvious naman po in rules of statutory construction na what is implied is cannot overturn what is expressed. So sabi na is what is expressed puts an end to what is implied. Or a person, object, or thing omitted must have been omitted intentionally. Kasi walang mention po ito sa resolution ng motion for reconsideration, Madam Chair. So with that, Madam Chair, I move that we set aside the first complaint because it was filed prior to the lapse of the 1-year bar rule, Madam Chair. I so move.
I object.
I object.
Before we act on the motion and on your objection, Honorable Erice would like to manifest as well.
Yes, Madam Chair. It's kind of tricky because in the Constitution, the initiation is a process when you file it and then the Speaker refer it to the Committee on Justice. That's the Constitution. Kailangan pong mai-refer sa Committee on Justice. Yan po yung initiation. At meron pong ruling ang Supreme Court na February 6. Maliwanag din po yun. Pero may nakikita po akong malaking problema. Sapagkat kung may 1-year bar rule at naniniwala tayo na February 6 ang 1-year bar ang dapat na sunding petsa, bakit tinanggap yung complaint ng Office of the Secretary General? At bakit ito nirefer ng Speaker sa Committee on Justice? Ibig po bang sabihin, in the next few days, pwedeng mag-file ng complaint every day for the next 300 days? Tatanggapin pa rin ng committee, ng Office of the Secretary General at i-refer pa rin ng Speaker sa Committee on Justice at ang Committee on Justice ang magde-decide whether the complaint is within the 1-year bar rule. Yan po yung tricky question na dapat siguro nating pag-isipan.
Let us be reminded that the duty of the Office of the Secretary General to receive the impeachment complaint is ministerial. They cannot actually refuse to accept impeachment complaints which are being filed. And that is why it is incumbent upon us, the Justice Committee, to dispose of the issue of whether or not the impeachment complaints were filed, whether in compliance or in violation of the 1-year prohibition period. The same is true with respect to the duty of the Office of the Speaker to include the same in the order of business within the period of 10 session days from the date of transmittal. And the same is true as well with respect to the plenary in referring the same to the Justice Committee. Honorable Erice.
Meaning, Madam Chair, that anyone can file a complaint every day in the next 300 days. And it will be accepted by the Office of the Secretary General and it will be referred to the Committee on Justice by the Speaker. That will be the rule now.
Yes, Honorable Erice.
Thank you.
And we are in the best position actually to address this issue of whether or not there is a violation or there is a compliance with the 1-year prohibition period. Before I call you Honorable Tino, next in line is the Honorable De Lima. We are reminding the Justice members that there's a pending motion already raised by the Honorable Flores. The same has been seconded. We will just be finishing those who raised their hands for the manifestation. And I believe that Honorable De Lima is the last in this line.
Thank you, Madam Chair. I objected to the motion. This representation objected to the motion, and I'm compelled to also share my thoughts and share my views on this matter, considering that if we are to apply the contention of some of our members here about questioning the timeliness that is still barred within the 1-year bar rule, the filing of the first, and that also included the filing of the second, which was subsequently withdrawn. And as an endorser of the second complaint, I've always taken the position that the filing on February 2 was timely. It's within the constitutional deadlines, and it did not violate the 1-year bar rule. So, since ang pinagtatalunan po natin dito, kailan ba talaga? Is it February 6? Kasi sa una kasi, in the January 26 decision, it says the earlier July 2025 ruling's point of reckoning shifts from February 6. It has to be on February 6. Yun po ang nakasabi explicitly doon sa first or sa main decision. But did the January 28, 26 decision move the 1-year bar? My position is yes, in effect. It may not have been as explicitly stated in the discussion about the 1-year bar rule, but it is clear to me na ganun po ang epekto. Bakit po? Iniba ho kasi nila yung interpretation ng session days. Whereas before, it was supposed to follow our legislative interpretation, not necessarily calendar days, kundi yung kung kailan talaga yung kailan yung adjournment nung certain session, and then it will be resumed again in another new session day. So it does not necessarily cover or involve a calendar day. But in the February 28, 2026 resolution denying the MR, naiba na po. So dahil nga dun sa iniba nila yung definition ng session days as calendar days when the House is actually in session, the Supreme Court in effect or actually recalibrated the point at which the 1-year clock begins. So under the definition, the earlier July 2025 ruling's point of reckoning shifts from February 6 to January 21. Bakit ho January 21? Kasi ito po yung referral to the committee. The filing was earlier. If I'm not mistaken, was it January 14? January 14 is the inclusion in the order of business. But the referral was in January 21. So, by counting session days as calendar days when the House is in session, the 1-year bar rule or the 1-year bar would expire by January 21. Therefore, the earliest that a new impeachment complaint against VP Sara Duterte can be filed with the House is January 21, 2026. Hindi po kasalanan ng mga complainants na they relied on the latest redefinition, reinterpretation by the Supreme Court, which was also made the basis of denying the motion for reconsideration. It would be fundamentally unfair na kung ang i-apply pa rin natin, ang i-insist pa rin natin is the original date of February 6. It has been moved because it's the Supreme Court itself that recalibrated everything about the definition of session days. Napaaga yung reckoning point. So why fault the complainants by saying that is now violative of the 1-year bar rule when that is not their definition initially, but they had to follow. They followed the court. They complied with the constitutional timeline as interpreted by the court. They acted in good faith, definitely. Walang masama sa pagsunod sa pinakahuling interpretasyon or interpretative ruling o doktrina ng Korte Suprema. So I agree with both the Honorable Representative Rufus Rodriguez and also the Honorable Representative Teddy Ridon that it should not be January 6, but the earlier date, as a result, a necessary consequence of the Supreme Court's redefinition and recalibration of what the session days actually mean. We may not agree. I myself do not agree. But we have to follow that because that is the latest interpretative ruling. As I said, it would be fundamentally unfair for the complainants of the first. Kung nandito pa nga po yung second complaint, kung hindi pa na-withdraw, I will still be taking that position. Maraming salamat po.
Okay, our parliamentary
Madam Chair.
status is, there is a motion to set aside the first impeachment complaint in view of the violation of the one-year prohibition period. And we have expressed our positions on the matter.
Madam Chair.
Meantime, we will be suspending for 2 minutes.
Suspend. So, ano maghiganti? Ano bang gusto mo?
The meeting is resumed. Our parliamentary status. There is a motion to set aside the first impeachment complaint, that is Castro et al. Impeachment complaint, in view or on the ground of violation of the one-year prohibition period. The same has been seconded and the same has been objected to as well. Before we vote on the motion, we will hear additional manifestation from the Honorable Tino.
Thank you, Madam Chair. Of course, bilang endorser, I vehemently object to the motion to set aside the complaint that we endorsed on the issue of allegedly that the complaint was filed in violation of the one-year bar rule. Madam Chair, sa motion ni kagalang-galang na Keith Flores, ay binanggit po niya, tama, no, sinight niya at nakatungtong ang kanyang objection sa naunang ruling ng Supreme Court in Duterte versus House of Representatives. At sabi niya, 3 beses nga daw binanggit sa decision na yun, yung February 6, 2026 deadline, no, for the one-year bar, no. Let me cite just the third and last instance. Let me quote the third and last instance where the decision mentioned that date. Sabi rito, new impeachment complaints against the respondent, if any, may only be commenced no earlier than February 6, 2026. Let me emphasize the word used by the Supreme Court. May only be commenced, no? So ang punto po natin dito ay gumagamit ng bagong lengguwahe ang Supreme Court. No, the one-year bar rule, as we established earlier in the Constitution, speaks about initiation of impeachment proceedings. Yun po ang pinagbabawal. Ngayon naman, may bagong formulasyon ng Korte Suprema. Sinasabi niya, new impeachment, new complaint may only be commenced. No, so bagong, in effect, this is a new rule, no, na with respect to when an impeachment complaint may be filed in a timely manner. Meron na pong konsepto ng commencement. Sa rules po ng House, no, wala pong anumang pagbanggit sa issue ng commencement, no? Kaya po, tingin natin, hindi po nag-a-apply ang ruling na ito sa proceedings ng House on impeachment. Ang gusto ko lang pong ipanawagan sa komite at sa buong House, no, ay malinaw na separate and co-equal branch of government ang Kongreso at in particular sa House of Representatives nakakargo ang impeachment bilang pinakamataas na proseso ng pagpapanagot sa mga pinakamataas na opisyal, no? Kanina sinabi po ni Representative Chua, abay, mag-ingat na lang tayo, baka mamaya kapag inallow natin ang first complaint ay dali na naman ito sa Korte Suprema at baka mabasura pa, no? Ang hamon ko po at panawagan sa committee at sa buong House ay wag po tayong matakot sa sarili nating anino. Panghawakan po natin ang sariling rules ng House on impeachment. Tayo po ang institusyong ito, no, ang House of Representatives ang gumagawa ng sariling rules on impeachment at ang tanging may kakayahang magpatupad ng rules na ito. No? Sa rules natin, walang usapin ng commencement, kahit pa sabihin yan ng Supreme Court. No? Bakit importante po ito? Hindi lang po ito teknikalidad. No? Dahil kung hindi ito gagawin ng House, kung hindi panghahawakan, if we do not take ownership of our own rules and impeachment, then at every step, kahit sinong gustong hadlangan ang pagpapanagot sa ikalawang pinakamataas na opisyal o sino bang impeachable official, at any point pwede pong tumakbo sa Supreme Court para questionin ang rules natin. No, katulad na nga nung nangyari sa nakaraan. So therefore, no, ang punto natin, kailangang panghawakan ng House ang sarili niyang rules on impeachment. Dahil sa tanging sa pamamagitan niyan, maaaring magtuloy-tuloy ang impeachment at mapanagot ang mga pinakamataas na opisyal na walang takot na ibabasura ito because of some new rule that the Supreme Court may come up with, Mr. Speaker, Madam Chair. No, kaya po, muli, I vehemently object to the motion and urge the House to take ownership of its own rules on impeachment and to really fulfill its constitutional duty of impeachment. Maraming salamat po, Madam Chair.
Again, for the guidance of the justice members, we are deliberating on the compliance or violation of the first impeachment complaint with regards to the one-year bar rule. We wish to reiterate that the first impeachment complaint was filed on February 2, 2026, and we are in between two decisions of the Supreme Court, the July 25, 2025 decision, which expressly provides for February 6 as to when there can be the filing of the second impeachment complaint, vis-a-vis the resolution of the Supreme Court on our motion for reconsideration that is dated January 28, 2026, which by implication provides that the 10-year period lapsed last January 14 of 2026. So in view of these two decisions, the original decision and the recent resolution, we have disparity with respect to our positions on whether or not the first impeachment complaint indeed comply or violated the one-year prohibition period. And with that, I hope the justice members are properly guided with all the meaningful discussions that we have heard from our esteemed members of the Justice Committee. Soon we will be voting, but before we proceed to that, will the third endorser wish to say something about the compliance to one-year prohibition?
Yes, Madam Chair.
Yes, you may proceed, Honorable Ilago.
Yes, ang representasyon na ito ay isa rin sa mariin na tumututol sa motion na iset aside ang verified impeachment complaint na ating na-endorso. Matagal nang naghintay ang mga complainants. Marami ho dito ay kabilang din sa mga nag-file ng impeachment complaint batay sa betrayal of public trust noon pang nakaraang taon. Sila ho ay matagal na naghintay at matagal din na nagtitiis doon sa mga opisyal na pilit na tumatakas sa pananagutan. Dahil ho sa kanilang paninindigan, sila rin ay masusi na nag-aral noong naunang desisyon ng Korte Suprema hanggang doon sa motion for reconsideration, hanggang doon sa pinakahuling desisyon na nag-move nitong one-year bar rule. No kaya ho, isang malaking inhustisya ang hindi paninindigan ng House of Representatives sa sarili niyang mga rules, sa sarili nitong mga proseso pagdating sa paghahandle ng ganitong tipo ng napakahalagang mga proseso para sa transparency, para sa accountability at pagtitiyak na ang bawat piso ng pondo ng ating bayan ay nagagastos talaga para sa kapakinabangan, para sa pangangailangan ng tao. Kaya, Madam Chair, isa rin ho tayo sa mga nakikiusap na nanawagan na huwag tayong mangamba, bagkos tayo ay manindigan at panghawakan natin ang ating sariling House rules pagdating sa pag-handle ng mga impeachment proceedings at makita natin at marinig masama ang lahat ng mga complaints sa didinggin ng komite na ito. Maraming salamat.
We've heard already the three endorsers of the first impeachment complaint.
Just a quick manifestation.
Honorable Chua, I hope you will be the last because we will be proceeding to vote. Honorable Nasal, would you like to say something also?
Yes, Madam Chair.
Okay, so Honorable Chua and then Honorable Nasal and then Honorable Digamo and then we will vote already.
Thank you, Madam Chair. Madam Chair, hindi po tayo natatakot dito sa committee ito. Because the reason why we are trying to be careful with the interpretation of the Supreme Court decisions is because this is an issue of jurisdiction. Jurisdictional issue po to, which is very important. So, yun lang po. But of course, I hope the endorsers understand na we are not against them. Ito lamang pong pinag-uusapan because as already stated, lahat naman po during the past impeachment, the House did its homework, and in fact, we followed what is under the rules of the House. But the House is not the problem. It is the other department. No, the interpretation of the other department. And in fact, it was used when the impeachment complaint was forwarded to the Senate. It was used. The issue was used. So yun lang po. Hindi lang, kaya that's why we are trying to be careful. Thank you po.
I hope that the endorsers are listening to Kong Joel. He's saying that all of you are his friends. And he's not against you. He was just traumatized by what happened to the first impeachment process. That's what he's saying. Okay, so moving forward, we would like to recognize the Honorable Nasal.
Madam Chair, kaya po kanina, yung for my earlier manifestation, kaya
Yeah,
po
I
sinasabi
remember
ko
it's about the 1 year.
na sana po ma-resolve na nga, even before magkaroon po ng question on
Our perceived inconsistency of the original decision vis-a-vis the resolution is not for us to resolve really, but it is for the branch of the government which issued the same. The least we can do at this point in time is to be very cautious as we conduct this impeachment proceeding.
Thank you, Madam Chair.
The Honorable Degamo?
Madam Chair, last before after.
Madam Chair, you've said a lot already, Honorable Ko. After Honorable Degamo, we shall proceed to vote.
That is correct po. I agree with the explanation of our fellow members of Congress. But there's also one reason I would like to add why I believe that we have to proceed with tackling the other issues or other complaints. It is because of the discrepancy too of the signature in the affidavit of the first complaint. If you are to look at the signature there, the one in the, how do you call this, affidavit is different from the passport that is being presented as an ID, no? Or a, so parang the more that I am resolved to vote against taking into consideration the first complaint.
The manifestation of the Honorable Degamo is noted. Now we shall proceed to vote. Again, our parliamentary status, there is a pending motion to declare, to set aside the first impeachment complaint. That is Castro et al. Impeachment complaint on the ground of violation of 1-year prohibition period. The same has been seconded, the same has been objected to as well, and we shall now proceed to divide the House. Those who are in favor of the motion, please raise your right hand.
Motion po para
You may now put down your hands. Those who are not in favor of the motion, please raise your right hand.
the 1 year ban, 1 year.
You may put down your hands. Last, those who abstain, please raise your right hand. Secretariat, the result of the voting, please. with 22 votes in the affirmative and 10 votes in the negative,
Ay, bilang.
with 0 abstention. The chair set aside the first impeachment complaint, the Castro et al. Impeachment complaint, on the ground of violation of 1-year prohibition period. So ruled.
Hindi mo na sila
Chair.
The Honorable Ko.
Point of clarification only.
Come again?
A point of clarification.
Yes. What is your point of clarification?
Can this representation clarify what the meaning of set aside is? Ano po ba yung parang legal effect nito dito sa buong proceedings?
By set aside, it means that it will no longer be included in the proceeding of this committee.
Bilang.
With all due respect to the endorsers of the first impeachment complaints. But of course, I wish to state for the record that I think all our endorsers are members and ex officio members of the Justice Committee, and we encourage all of you to continue actively participating in the deliberation, if not as endorser, then as esteemed members of the Justice Committee.
Thank you, Chair.
That is for the record. We shall now proceed to our determination in form. Because of the withdrawal of the second impeachment complaint and the setting aside of the first impeachment complaint, it now appears that there are only 2 impeachment complaints. The third and the fourth. The third is the Reverend Father Sabala et al. Impeachment complaint, and the fourth is the Cabrera impeachment complaint. We are now proceeding to the determination of sufficiency in form. May we request the endorser of the third impeachment complaint to make a quick manifestation as to her position with respect to the third impeachment complaint, sufficiency in form.
Thank you, Madam Chair. As a quick manifestation on the issue of the determination of sufficiency in form of the third complaint that I endorsed, I strongly manifest that the verified impeachment complaint filed by Reverend Father Sabali et al. And duly endorsed with his representation is sufficient in form. In fact, more than sufficient in form. Naniniwala po ako na dun sa Gutierrez versus House Committee on Justice, GR number 193459, February 15, 2011, ang sabi ng Supreme Court, the House has formulated determinable standards as to the form and substance of an impeachment. It further says, the impeachment rules are clear in echoing the constitutional requirements and providing that there must be a verified complaint or resolution. There is a verified complaint, duly signed and dated. It was filed through counsel or assisted by counsel, the Sapayan, Lim, Alvarez, and Ligutan, or sa legal law offices, and complainants are members of the clergy, priests, pastors, and nuns, members of the bar, and members of NGOs. They are residents of various localities in the Philippines. The complaint was filed last February 9, 2026. No issue on whether or not there is violation of the 1-year bar rule because it was filed February 9 or after February 6. At nung final po nung February 9, itong third complaint, dun sa araw na yon, the first 2 impeachment complaints, yung second nga po ay na-withdraw na ngayon, on February 2, were not yet included in the order of business. By February 9, 2026, only 3 session days elapsed. So, complainants filed the third impeachment complaint within the 10 session day requirement as interpreted by the Constitution. Na, it's not really the session days that we are used to adopting, but the calendar day where session is held. On February 23 po, yung pag-include sa order of business. He did so, the Speaker did so within 10 session days of the February 2 the February 2 session. On the same date, the House referred all the impeachment complaints to the Committee on Justice
their referral was also well within the 3-day session day requirement under the Constitution. Verification, the requirement of verification, it squarely complies. Nakalakip sa complaint ang individual separate verifications and certifications of non-forum shopping of each of the 13 complaints. Hindi po ito joint verification but individual. Kung saan malinaw na pinahayag under oath ng mga complainants na kanilang nabasa, ang complaint at ang mga aligasyon ay totoo at wasto batay sa kanilang personal knowledge o sa authentic records. Ito ay pirmado at sinumpaan sa harap ng iba't ibang notary public dahil nga po galing sa iba-ibang lugar yung complainants. Yung endorsement, wala rin pong problema. It's here, the resolution endorsing the impeachment complaint. This is on the top of this of the complaint with its annexes. So kung ang tanong ay nasunod ba ng complaint na ito, mga formal requirements, alinsunod naman sa Constitution at sa rules, ang sagot po ay oo. Thank you very much.
Thank you, Honorable De Lima. Now we're opening the floor for comments and manifestation of the Justice members.
Madam Chair.
The Honorable Ann Matibag.
Madam Chair, I would like to agree with our Honorable Senator Leila De Lima that the third complainant is signed and verified by the complainant, Reverend Father Joel Sabale et al. And attached to the complaint, Madam Chair, are the verifications of the complainant.
All right. Any other member who wishes to manifest their comment as to the sufficiency in form of the third impeachment complaint, that is Abalia et al. Impeachment complaint?
Madam Chair.
The Honorable Franz Legaspi.
Thank you, Madam Chair. Just a quick manifestation as well, just to support my colleague Kong Ann Matibag and of course to Kong Laila. I think it's quite clear to everyone here that the form is sufficient in the sense that it complied with the verification requirement, it complied with the rules that we have, specifically Section 3 of Rule 2 of the impeachment proceedings. Particularly upon reviewing the complaint earlier, it's clear it fulfilled the requisites, basically that the affiants are the complainants, the affiants had read and understood the complaint, that more importantly that they are based on the true and personal knowledge or authentic records and documents. So aside from that, I also like to highlight that there's compliance by the clergy and the other people's organizations here, and that this complaint clearly, as mentioned by Kong Laila earlier, was properly endorsed by her office via a resolution as well. So thank you, Madam Chair.
Thank you, Honorable Legaspi. Any other member? Honorable Chua?
Thank you, Madam Chair. Madam Chair, I would like to share the observation of the endorser, the Honorable Laila De Lima, that the third impeachment complaint has faithfully complied with the Supreme Court's ruling and the pronouncement on impeachment. I totally agree that it is within the period as provided, and in fact, it was filed on February 9. It was included in the order of business on February 23, and on the same day, it was also referred to the Committee on Justice within the time frame as provided by the Constitution, by the rules, and by the Supreme Court's decision. Thus, it is my view that the third impeachment complaint complies with the jurisdictional requirement when it comes to the issue on one-year bar rule. And hence, it is timely filed.
Just wish to state for the record that the third impeachment complaint was filed on February 9, 2026, and then was included in the order of business and referred to this committee on February 23, 2026. That is for the record. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Well, I fully support as far as that issue is concerned. I have a point of inquiry what is the effect of the complaint which we had just previously dismissed on this third and fourth complaint. Look, we said, that's the decision of this committee. It was filed within the prohibitive period of 1 year, but it was referred to by this committee, and this committee had decided that it was within the 1 year bar rule, so we did not consider it. What will be its effect? Will it bar this third and fourth complaint?
The Honorable Dumogan, I understand that the issue with respect to the first impeachment complaint has been resolved already.
Yes, and what is the effect of the decision of this committee not to consider it, because it is within.
The only consequence of that ruling, Honorable Vice Chair, is for us to be able to proceed with the third and fourth impeachment, and we will not be including anymore in our deliberation the first impeachment complaint. That is the consequence of the ruling of the motion.
I am worried on that ruling. Anyway, it's my view. I'm really worried on that ruling.
Madam Chair,
The Honorable Dilima.
just to add a point, whether it was the earlier period, which is
January 14.
January 14 or 21, because 21 is a referral to the committee, or the February 6, which is the one stated in the main decision, this does not violate, the third complaint did not at all, or does not violate the 1 year bar rule, since yung pinakauna na mga na-file was February 2. And therefore, dun nga tayo nag-count ng 10 session days and 3 session days thereafter. So no problem at all, no effect on the third and even the fourth complaint.
Yes, that is correct. We totally agree to that whether we consider the January 14 as the lapse of the 1 year prohibition period or the February 5 to make it possible for the second impeachment on February 6, the third impeachment complaint rightly falls within the allowable period in both dates as perspective. If there are no other members who wish to comment on the sufficiency in form of the third impeachment complaint, we shall proceed to hear the position of the endorser of the fourth impeachment complaint. No more members?
Madam Chair,
We recognize the Honorable Deputy Speaker Paulo Ortega to manifest his position with respect to the sufficiency in form of the fourth impeachment complaint, that is Cabrera impeachment complaint.
thank you, Madam Chair. Maikli lamang po, would like to manifest that in terms of form and requirements, the fourth impeachment complaint has complied in terms of form, and we have endorsed it on the date February 18, 2026. Thank you, Madam Chair.
Thank you. Now we are opening the floor for comments and manifestations of the Justice members with respect to the sufficiency in form of the fourth impeachment complaint. The Honorable Zamora is recognized.
Thank you, Madam Chair. As regards the fourth complaint, the complainant, a certain attorney Nathaniel G. Cabrera, signed the same and also executed a verification which states as follows: the allegations in the complaint are true and correct based on my personal knowledge or based on authentic records. The verification was signed and notarized on February 18 in Quezon City and was notarized by a certain attorney Jason San Buenaventura. The resolution of endorsement by Representatives Benvenido M. Abante Jr. and Representative Francisco Paulo B. Ortega V was signed on February 18, 2026. Both of them subscribed and swore before the Secretary General on even date. So, Madam Chair, we believe that the fourth impeachment complaint is compliant with the requirements of the sufficiency of form. Thank you, Madam Chair.
Any other member who wish to comment on the sufficiency in form of the fourth impeachment complaint? No more? Can we proceed to vote now? as agreed upon at the onset, after we conclude on the deliberation on all the impeachment complaints, which at this point we only have two, the third and the fourth impeachment complaint, we shall proceed to vote. The chair is now ready to hear the motion with respect to the sufficiency or insufficiency in form of the third impeachment complaint.
Madam Chair.
The Honorable Zamora.
Madam Chair, I move to declare the third impeachment sufficient in form.
There is a motion to declare the third impeachment complaint sufficient in form. Do I hear a second? Is there any objection? Hearing none. The chair declares the third impeachment complaint, that is Father Zabalia et al. Impeachment complaint, sufficient in form. So ruled. The chair is now ready to hear the motion on the fourth impeachment complaint. The Honorable Padiernos.
Madam Chair, I move to declare the fourth impeachment complaint as sufficient in form.
There is a motion to declare the fourth impeachment complaint, that is Cabrera impeachment complaint, sufficient in form. Do I hear a second? The same has been seconded. Is there any objection? Hearing none. The chair declares the fourth impeachment complaint, that is Cabrera impeachment complaint, sufficient in form. So ruled.
Madam Chair,
The Honorable Marcoleta.
point of order. This is not directed to the members of the committee.
Madam Chair, our good friend is not a member of the committee.
Yeah, but I can
Perhaps
It's a
you
point
can
of
just
order.
manifest
Or just
instead of raising a
manifestation.
point of order.
manifestation.
All
Not
right,
directed.
you may proceed, Honorable
This
Marcoleta.
is not directed to the members of the Justice Committee, but I observed the presence of Mr. Kiko D from the audience. Though he was allowed to be an audience in the proceedings, despite his withdrawal of the second impeachment complaint, I suggest that he observe proper decorum. Because if you remember,
May we know the action of the Honorable D or Mr. D, which is not consistent with decorum?
I'm just speaking from experience when the
Which means he hasn't committed any yet.
not yet, but as a forewarn, as a premonition or a warning, he during the archiving of the impeachment at the Senate, Mr. D,
Madam Chair,
Mr. D,
Madam Chair, wala pa naman palang ginagawa. Let us not...
Point of order. Let us wait until he finishes, and then I will
just
be
allow me to
recognizing him.
finish. During the archiving of the impeachment, Mr. D booed and made a gesture of thumbs down at the VIP gallery of the Senate.
All right. Honorable Marcoleta, but it is
It's for them
apparent
to observe
that
proper decorum.
the Honorable D hasn't committed anything yet which is not consistent to decorum. Would you like to say something, Honorable Dilema?
Yes, Madam Chair, it is completely improper for our colleague here to raise that matter. And he has not cited any act of misconduct or misbehavior on the part of Mr. Kiko D. And alluding
Would you
to
like
that,
to make a
alluding-
motion to that effect?
Yes, my motion is to strike out the manifestation.
Second, Madam Chair. There is a motion to strike out from the record the manifestation of the Honorable Marcoleta. The same has been seconded. Is there any objection? Hearing none, the motion is granted. The manifestation of the Honorable Marcoleta is hereby ordered stricken out of the record. If there are no other matters which the members wishes to discuss, the chair is ready to hear your most favorite motion.
Move to adjourn, Madam Chair.
There's a motion to adjourn. The same has been seconded. No objection. Our meeting is suspended until tomorrow, 10 o'clock in the morning.
Oh, thank you, Lord. It's done. Yes, may
Madam Chair.
dalawang complaint.
You have to correct the motion, though.